introduce our panelists. We have here on your right, Don Oberdorfer, who is the diplomatic correspondent for the Washington Post and has been so for 11 years. He is, can you hear that? Okay, all right. No? Yes? He is the author of the book Tet, published in 1971. Next to him is Richard Willard, now Assistant Attorney General for the Civil Division in the Justice Department. Mr. Willard served as an Army intelligence officer in Vietnam, as a clerk to Anthony M. Kennedy and to Justice Blackmun, and since 1985 has held his present post. In 1981, he was the Attorney General's Counsel for Intelligence Policy. Floyd Abrams is a well-known First Amendment lawyer and has argued more press cases before the United States Supreme Court than has any other attorney. And Professor Henry Holzer, on your left, has been on the faculty of the Brooklyn Law School since 1972 and is most recently the author of Sweet Land of Liberty, whose title has a question mark after it. Professor Holzer.
Let me indicate in advance the tenor of my remarks by indicating to you that my working title is Protecting America from the First Amendment. When we talk about national security or national security interests, what I'm talking about at least is the government's legitimate concern with defending itself from violent overthrow or subjugation by domestic subversion or external aggression. And indeed, the term national defense has meaning and texture given to it through cases interpreting the Espionage Act at 18 U.S.C. 793, etc. I want to remind you at the outset that the title of the panel is the First Amendment and National Security, so we are not talking about a lot of things here. And I had some notes on what we're talking about, but I'm not going to go into them because I think I'll need the time. But suffice to say, by way of example, that we're not talking about domestic surveillance, we're not talking about travel restrictions, loyalty tests, that kind of thing. Also, we're not concerned with, as I see it, primarily with the acquisition of information, but rather the disclosure or the dissemination of material in the sense of a First Amendment right of speech or press. And indeed, because the topic is the First Amendment and national security, I'm not going to be talking about things like dirty pictures, but rather about survival. A basic premise that I think everyone must begin with is that the United States of America has national security and national defense concerns because the 20th century world and the foreseeable future is a very, very dangerous place. You don't need me to tell you that. Dr. Brzezinski, Secretary Weinberger have alluded to that quite effectively earlier today. There are people out there who want to hurt us, from the Soviet Empire and the Iranian fanatics to freelance gangsters like Gaddafi and Abu Nidal. So the non-disclosure aspect to our national security, national defense concerns is directly related to our survival. Now, many reasons are given for the espionage laws, for official secrets acts, things like that. Our allies won't deal with us, how can they rely on us, and so forth. But when you exhaust the laundry list, and it's a long one, of practical concerns, it comes down very simple to a question of national survival. Yet, despite certain disclosures, which actually and potentially threaten our survival, there are all sorts of people, for differing motives, who have revealed and who wish to reveal a variety of information to various recipients. Spies like Colonel Abel, self-styled patriots like Daniel Ellsberg, who was really a thief, journalists like Woodward, traitors like the Walkers and the Rosenbergs, zealots like Pollard, former government employees like Pelton, Snepp, Morris, and Turner, and Agee, and if you like, you can put Agee on the list of traitors, politicians like Pat Leahy, or as I like to think of him, Leaky Pat Leahy. The motives vary: greed, anti-Americanism, pro-communism, power, political advantage, scholarship, in quotes, ego, fame. And the information, of course, runs the gamut: atomic bomb secrets, codes, covert projects, reports like the Pentagon Papers, technical information, surveillance, and something I'll come back to in a few moments called the Special Navy Control Program. And the recipients of all of this, ultimately, our enemies, ultimately the USSR, and of course, even our allies, if the disclosure of this material can hurt us or embarrass us with our allies. How does it work? First, there's acquisition. A prospective discloser somehow obtains material, maybe legally through employment, or maybe illegally. In other words, he steals it or he gets it from a thief. So far, at this point in the scenario, it's a general criminal law problem. The motive might or might not mitigate the theft, but of course the First Amendment does not yet approve stealing. I haven't seen the advance sheets today. I haven't read some of what our distinguished Supreme Court justices have said on the subject lately, but as of yesterday at least, the First Amendment did not protect stealing. But today we are not concerned with acquisition. The second stage is that sometimes government learns between the acquisition and the disclosure that something is obtained and is about to be disclosed, as in the Pentagon Papers situation, and the issue of prior restraint then arises, which I will address in a few moments. And the next stage is disclosure. Disclosure occurs to whom? Well, to the KGB or the GRU resident at the Soviet consulate, to the New York Times or the Washington Post or the Daily Worker, to Newsweek magazine, to Israel, to Dan Rather, to whoever. And because a Julius Rosenberg loves communism, or a Pat Leahy wants to be a big shot, or a Philip Agee hates America, or the Walkers need money, or whatever, we lose secrets and we become even more at risk. Now, there is somewhat of an arsenal against harming America's national security by disclosure of sensitive information. There are some weapons, and I won't give you the laundry list. Suffice to say that there are some narrow, precise situations like atomic energy, which are covered by specific acts. The former CIA employee is covered by yet another set of very narrow safeguards. And I'm thinking, of course, about the employment contract and the Marchetti and Snepp situations. There is, of course, punishment of what I, for the moment, would like to call straight espionage. Believe it or not, other than these and two others, which I'll mention in a moment, that's it. Another is 18 U.S.C. 641, which covers thefts and embezzlements of government property or things of value, which is not an easy statute to use, of course, in disclosure of national security, national defense information. And the other is the prior restraint preliminary injunction, which is contemplated by Neer against Minnesota in the Pentagon Papers case. But this, of course, currently is a judicial weapon. It's something that can be sought and obtained, if at all, from the court, and it doesn't rest on any significant or any statutory basis. So the question is then, where do we stand with regard to spies like Abel? Well, we're in pretty good shape. And what about traitors like the Rosenbergs and the Walkers and Pelton? We're in pretty good shape. And zealots, people who are, for one reason or another, determined to give sensitive information to foreign governments, even friendly governments, even allies. We're all right there pretty much too. What do we do about leakers and their henchmen in the media? Now, Dr. Brzezinski both said and alluded this morning to a leaker problem. I'm sure virtually everybody here knows that that's a very serious problem. What do you do about an alleged do-gooder like Ellsberg? You can't apply the Espionage Act. You can't apply a specific Atomic Energy Act type statute. It's really not theft, and even if it is, it doesn't go to the disclosure. He didn't work for the CIA, so we don't have an employment contract, the Marchetti-Snip situation. And at least in that situation, you couldn't enjoin him. What do you do about Woodward? October 26, 1987, as many of you know, I'm sure, Insight magazine referred to, quote, one of the most closely held secrets in American intelligence, the Special Navy Control Program, which apparently Turner gave him. Is there a statute that fits that? I think not. And what do you do about Leaky Leahy, where he shoots off his big mouth about the Achille Lauro and sensitive operations in Egypt? How do you deal with that? Well, I think the way you deal with it is by enlarging present laws or getting new laws enacted to provide that an unauthorized disclosure of national security, national defense information, which is not currently embraced by these statutes. In other words, leaks by anyone, including the heretofore specially privileged media, to anyone for whatever purpose, one, may be permanently enjoined with substantial financial and other penalties for violation of the injunction, and two, punished criminally. Now, obviously, and shortly I'm sure someone will accuse me of the next statement simply being lip service. Obviously, statutes like that have to be drawn to avoid vagueness problems. They have to narrowly define key terms like unauthorized disclosure, national security, national defense. The legislative intent, hopefully, should be very clear. And there is somewhat of a common law injunctive remedy that still exists. Now you say, as doubtless someone here will, what do we do about the First Amendment? And I will anticipate that and quickly summarize why the First Amendment is no bar. In the first place, there can't be a speech or a press right to take affirmative steps to disclose information which in the hands of America's enemies could violate the legitimate rights of Americans to survive. In other words, there is no right to violate a right. Secondly, no Supreme Court has ever held the First Amendment is entitled to a privileged position, either in the Bill of Rights or in the entire constitutional constellation of which the First Amendment and the Bill of Rights is but a part. Third, federal courts of appeals at least have held, in the case of the Rosenbergs, that they had no First Amendment right to pass atomic secrets to the Soviets. And indeed, one can extrapolate from that Axis Sally had no free speech or free press right to broadcast pro-Nazi, anti-American propaganda for the Germans, or Tokyo Rose for the Japanese, or Ezra Pound's anti-Semitism for the Italian fascists. Indeed, in the world today and in the United States today, there are many limitations on speech. And though some of us may disagree with some or all of them, they have been held constitutional, and they are indeed the law of the land. And some deal with infinitely less important material than national security. Obscenity, hardcore pornography, is a limitation on speech. Defamation is a limitation on speech. Dirty words are a limitation on speech. Commercial speech, the doctrine, is a limitation on speech. Speech in special environments, time, place, manner restrictions, are a restriction on speech. The Hatch Act, barring political activity, is a restriction on speech. The Logan Act, freelance foreign policy, except, of course, when it applies to the congressman, is a limitation on speech. In addition, national security and national defense issues are related to foreign affairs. The foreign affairs power of the federal government, said by Sutherland and Curtis Wright to be plenary, is indeed plenary, especially when the President and the Congress act jointly. And on any balancing, for those who like to do that sort of thing, it is not difficult to find a compelling state interest here. Now, what about pre-publication restraint? Pardon me. Let me say for the moment, and make it clear while I do that there's much more to be said about this, and perhaps I'll get a chance to say it later, that in principle, there is nothing constitutionally infirm about a pre-publication injunction. Near against Minnesota does not say that you can't ever get one. The Pentagon Papers case didn't say you can't get one. Indeed, Brennan himself, in the Pentagon Papers case, recognized in principle the availability of a pre-publication injunction. And indeed, in the Progressive case, which dealt with the recipe for the atomic bomb, a district judge did indeed issue a preliminary injunction. So let me conclude by saying the following. Our laws relating to disclosure of national security defense information must be tightened, they must be enlarged to cover leakers and their arrogant henchmen in the media who presume to decide for the American people who have elected a president and a Congress what's in the national interest concerning security, and those laws must be vigorously enforced. The Morrisons who give secret photos to a British magazine should be prosecuted as he was. The AGs who blow the cover of CIA agents ought to be tried, not only for that under the new statute, but perhaps for treason, and even given the death of Mr. Welch in Athens for being an accessory to murder, which AG got away with. Welch, I might add, has no longer any freedom of speech. The former government employees and journalists who compromise secret papers, secret projects, must be indicted, tried, convicted, sentenced, and sent to prison, whomever they are. And the self-serving, holier-than-thou newsmen who would jeopardize American security by exposing a planned Grenada invasion or a hostage rescue operation must be enjoined and severely punished if they violate that injunction. Our survival in this very dangerous world requires no less. And to paraphrase William Jennings Bryan, it seems to me that we can no longer allow America's security to be crucified on the cross of free speech. Thank you.
Good afternoon. Those of you that were here last year when I was here may recall, although there's no reason for you to, that at that time I urged those members of the administration that were engaged in judge picking to look very carefully. And I said that if they wanted to make a dazzling lurch towards the center, that they should consider other people than the usual Federalist Society fellow travelers. That is not a topic that I think will endear me to you today, and I will put aside any references to judge picking. But I have a cause today. I wasn't sure what I was going to talk about, and Professor Holzer has made my life easier. Let me start at the beginning. Each society chooses the risks it is prepared to take. And each society, I think, chooses in the area of national security and freedom of expression the risks that it is prepared to take in either direction. As a general matter, this country, more than any other in the history of the world, has chosen the risks of speech rather than the risks of suppressing it. That is true in almost all areas. It is surely true in the area of national security. I have not the slightest hesitation in telling you that to travel abroad when one does what I do for a living and tell people about cases that I've worked on or cases that the courts have decided is to be confronted continually with a look that is usually reserved for people who are slightly mad. It is the received wisdom of the Western world, not alone the totalitarian world, that we have gone too far, much too far, that we do not understand the value of order, that we should be concerned, as Secretary Weinberger put it, about momentary spasms of public opinion, and that, as Professor Holzer would have it, we should do something about the press when it publishes things that it really shouldn't print in the first place, at least what Professor Holzer believes that it shouldn't print in the first place. I come to you with a few lessons I offer you, or a few lessons I would urge upon you. One is that when people talk specifically about the harm that something that has been published in a newspaper or broadcast on television will do or has done, that you should be very, very cautious about accepting its accuracy. We have, after all, had some experience in this area. The Pentagon Papers, which Professor Holzer refers to, were secret, indeed in classification terms, top secret documents prepared under the auspices of Secretary McNamara in an effort to determine why we went into the war in Vietnam and whether, at least in a sense, whether we should stay in that war. They were made available to the New York Times and ultimately to other newspapers, and as Professor Holzer rightly says, the prior restraint in that case failed, but the court did not say that all prior restraints would hereafter always be unconstitutional. What it did do, though, was to make it just about impossible for any prior restraint to issue in just about any case we can imagine. The fact that we had no efforts by the government to seek a prior restraint on national security grounds ever before 1971, and no cases since 1971, save the progressive case, which didn't reach the Supreme Court, should tell us something about how real life works, what it is that is published, and how much harm people really think it can do, and indeed how much harm it does do. In the Pentagon Papers is only one case, but it's not a bad test case. There, under oath, the Secretary of the Army swore to every court in this country that publication of those papers would do, quote, grave and irreparable harm, unquote, to this nation and its people. All those papers, which were in the hands of newspapers, were ultimately published. In fact, some of them not by the newspapers themselves, but ultimately they were all published. No one has even tried to argue that any harm came about as a result. I am an eyewitness to interview 10 years after that case every witness I could find who had testified for the government about the harm that would befall us as a result of publication. None of them thought that any harm had come about, and one of them, Mr. McComber, former Assistant Secretary of State, later Ambassador to Jordan and other countries abroad, said that he now thought the government's position was wrong, even though he thought it should have been brought. He thought the Times should have won the case, and he said that he had come to the view, more strongly out of government than in it, that the First Amendment protects our national security, protects it, as well as always running the risk of imperiling it. I think that teaches us a lesson about this. Professor Holzer refers to Mr. Woodward and asks, I hope hypothetically, what do you do about Woodward? There are a few things that I think ought to be said about that. First, if you're serious about punishing leakers, you should ask, what should we do about the Caseys? If you mean that you really want to punish people that leak information and jail them, then you have to mean it on a bipartisan basis, across the board, whether the people come from the left or the right, whether you agree with them or not. And Mr. Woodward's book is a good example of that, because no one that reads that book, unless you just think he made it all up, no one can read that book and not believe that that information came from high-ranking officials, whoever they were, in the intelligence establishment of the United States. But suppose we were starting fresh. Should we? Forget the First Amendment. I mean, I really win this First Amendment argument in terms of what the law has become. We live in a country free of prior restraints. We live in a country, as Professor Holzer said at the start, which has banned very, very little speech in this area. And the case law, I would at least argue to you, is extremely strong against imposing liability, not on people who leak, not on the AGs, who I happen to agree with Professor Holzer about, but about third parties who receive the information. There is at least very powerful case law in their support for the proposition that if you get information, you can do with it what you want. Should that be the law? Put aside First Amendment. Should we live in a society, should we choose to order a society in a fashion which lets us, once we have information, use it as we see fit? My answer is yes. And I think my answer comes from some of the same roots that the First Amendment case law that we've had comes from. In part, it's a matter of practicality. Once secrets are out, they're out. They're really out. You can't rebottle old secrets. You can't effectively ban the use of information which is once out of the government, which is trying to prevent its dissemination. That is indeed exactly what happened in a different part of the Pentagon Papers case. One newspaper after another got the information. One newspaper after another was enjoined. We were going down a road similar to the absurd situation the United Kingdom is in today, where the book Spycatcher, which we can buy at any newsstand in America, which any Englishman can bring into England, which most people in the Western world can read if they choose to read, can't be printed in the United Kingdom and can't be printed in excerpts in the United Kingdom either. It doesn't work, and it shouldn't work. Who are we protecting? What are we protecting? We should at least say that if information is out, there is some reason to assume that our adversaries in the world are able to get it, or have gotten it, or could find a way to get it. That is not a reach, a stretch. You don't need traitors for that. Once something isn't a secret, it isn't a secret anymore. More than that, we should at least put some component, even if, as I say, we forget we have a First Amendment, some component of freedom of expression on the scale. Are we really prepared to say, and I may say to you, all of you directly, is a libertarian organization like this really prepared to say that if you have information which is relevant to public policy decisions, as a lot of this information is, that you may not use it, that you will be jailed, are to be jailed, should be jailed if you disclose it to someone else? That is at the heart of what Professor Holzer is talking about. Washington lives on leaks. Now, Mr. Willard has said in a previous discussion that he and I had some years ago that it was one of the purposes of this administration to end that regime. It has failed. All administrations so far have failed at that effort. I don't condemn them for trying that. I simply say that no administration has found it possible to do that for a variety of reasons which are deep-seated, and I think, in the American psyche, and which particularly come to the fore when we don't agree on basic premises of policy within government and without government. But to say that we should jail people who get information from whom? Government officials, high-ranking government officials, often government officials who have authority to leak, since that's the way Washington works and has always worked. Low-ranking officials who have or don't have authority to leak. The truth is, I would argue to you, that one of the primary ways the American people learn what's going on in and about their government is by leaks. That is not an ordered way to run a society, heaven knows. It is not the way one would start out writing law in terms of how society ought to work. It is the way we have developed for a variety of reasons. It is the way information gets out. I don't oppose criminal laws which deal with certain people in government who reveal certain information. I don't object to laws which result in the firing of other people. You don't even need laws who are in government who leak information. But when I hear the question, what should we do about Woodward? My answer is that we should honor him. I think he has made a serious and substantial contribution to public debate about the most serious public matters that confront us. If we were drafting a First Amendment, we should draft it to protect Bob Woodward. And if we were drafting a new espionage law, we should draft it to make sure that the Woodwards of the world were not jailed because of what they did. So I conclude, ladies and gentlemen, by urging on you, and I don't want to act as if I have some personal rapport with you, but you people in particular are people who occasionally tell me that you really care about personal liberties. And I tell you that passing legislation which bans speech, which suppresses speech, which punishes speech, is something which should not commend itself to you in particular. Thank you.
It's certainly a pleasure and an honor to be here today with you at this symposium and on this distinguished panel, and to follow Secretary Weinberger, who has certainly been one of my heroes in the administration. Now that he's leaving, there aren't going to be very many of us who have been working as political appointees in the Reagan administration since January 21st, 1981, which is the day I started. Sometimes I think that part of success in Washington is outlasting your adversaries, and certainly Secretary Weinberger and I have at least lasted as long as we have. That has something to do with your ability to do things. Experience, though, also teaches you an appreciation that events may not appear to be the way they are when you first look at them. And I certainly think and hope that I've learned something during my time in Washington. Caused me to have a somewhat different perspective on these problems than I did a few years ago, back when Floyd and I were on the debating circuit about the First Amendment and national security. I should say that I ought to start out by being happy today about the government's record in these cases. Floyd has been dwelling on the Pentagon Papers case, but if we look more recently, the government has been winning cases in which the First Amendment and national security interests come into conflict. I'd just like to briefly summarize them. Starting in 1980, and this was the Carter administration, so I can't claim credit for it, but it was the beginning of a trend. In the SNEP case, the Supreme Court upheld pre-publication review of unclassified writings of ex-CIA employees by the agency over a First Amendment challenge. The next year, Hague against Agee, again rejecting a First Amendment challenge, upheld the ability of the government to revoke Mr. Agee's passport because of his activities. Then we went several years later, Regan against Wald, upholding the travel to Cuba regulations, again over a First Amendment challenge. CIA against Sims, Freedom of Information case, not a constitutional case, but one I had the pleasure of representing the government in the Supreme Court. We won, upholding the ability of the Director of Central Intelligence to keep secret intelligence sources, even though they were unclassified, and to protect them. Then a couple of cases in 1985, Albertini upholding the power of military commanders to bar people from open houses where they wanted to demonstrate on a military base, and Waite upholding the ability of the government to engage in a Selective Service Act prosecution policy that was targeted at people who had protested against the act. And then finally, Meese against Keene, the Canadian films case, which Floyd used to criticize us about. Again, we won that in the Supreme Court, upholding the ability of the government to compel foreign films to be registered if they were classified under a statutory term as political propaganda. In fact, now I may have missed one or two. The only one I know of where we had a problem this term, the Abrams case, we lost that, and it was affirmed by an equally divided court 3-3, with 3 members of the court absent, and I'm not sure that really stands for much of anything. And I'd like to say one other thing about this whole series of cases we've been winning, involving First Amendment or First Amendment-like considerations weighed against national security interests in the Supreme Court. These haven't been close. Only one of them, Regan against Wald, was a 5-4 case, and there the 4 dissenters based their dissent solely on statutory, not constitutional grounds. Most of these cases were 7-2 or 6-3. In fact, the only justices to vote against the government's position in all 7 of the cases were Justices Brennan and Marshall. Justices Stewart and O'Connor and Berger and White and Rehnquist voted for us in all of the cases. Powell voted for us in 6 out of 7, Stevens in 5 out of 7, and Blackmun in 5 out of 7. So it hasn't even been close. We've been winning First Amendment cases involving national security issues in the Supreme Court. So I ought to come before you pretty happy, thinking that maybe we've done a pretty good job and things are not as bad as Professor Holzer has painted the picture. But the fact is, I come before you very unhappy about the state of our government's ability to protect national security information. As Floyd pointed out, a few years ago, I was optimistic that the Reagan administration could change the traditional Washington pattern of rampant leaks in which national security was constantly being compromised by the flow of unauthorized information through the media, and we have failed. We have failed miserably in any effort to protect our vital national security secrets. And this has caused numerous harms in terms of expense, of compromise of our intelligence programs and capabilities, of making it harder for us to conduct diplomatic activities, of endangering the lives of American servicemen around the world. But I'd like to focus on one particular harm, because this is one that I predicted, and unfortunately I'm here long enough later to say I told you so about it, and that's the harm to the decision-making process. We were told that in the planning for the Iranian hostage rescue mission in the Carter administration, that one of the problems with it was that the fear of leaks kept the planning to such a tight circle that they couldn't take advantage of the expertise that might have helped the mission be a success. People who are involved in it, Colonel Beckwith in his book and others, pointed that out. The people who had the expertise, who could have been helpful, were kept out of the process because they were afraid that if they involved too many people, it would leak. And that led to the foreign policy fiasco of the Carter administration. And unfortunately, the same fear led to the foreign policy fiasco of the Reagan administration, and I'm referring to Iran-Contra. The Tower Commission report, and I'd just like to quote a few sentences from it because it makes the point quite well in this regard, stated, "The obsession with secrecy and preoccupation with leaks threatened to paralyze the government in its handling of covert operations. Unfortunately, the concern is not misplaced. The selective leak has become a principal means of waging bureaucratic warfare. Opponents of an operation kill it with a leak. Supporters seek to build support through the same means. We have witnessed over the past years a significant deterioration in the integrity of process. Rather than as a mean to obtain results more satisfactory than the position of any of the individual departments, it has frequently become something to be manipulated to reach a specific outcome. The leak becomes a primary instrument in that process. This practice is destructive of orderly governance." I think that that is a fair comment on the kind of problem that helped to contribute to the Iran-Contra fiasco. And the question is what to do about it. Well, maybe we should give up. As Floyd suggests, maybe we should just recognize leaks are a phenomenon of Washington. That's the way Washington communicates with each other, in officials and unofficials, and live with it. But I don't think that that is an adequate answer. I think we would be abdicating our responsibilities, those of us who are in government, in having in mind the responsibility that we have, the President has, and those of us who work for him, to safeguard the national security, to tolerate a situation in which our government can't keep a secret when it counts. So the question is what to do. And I don't think that the First Amendment has much to do with the solution. In my view, the solution is one of painstaking, hard work to the fundamentals of security. I've come to the view here in Washington that getting success in government is like success in invention. It's about, which is 1% perspiration, 1% inspiration, 99% perspiration. That success here, maybe the numbers are a little different, but it's about 10% in policy making and 90% in policy effectuation. And in the national security area, I think that's quite true. We need to have a balanced program of developing a security posture that pays attention to all the fundamentals. In my view, and I'll just tick off the 5 areas, they involve a sound classification system, a personnel security system that works properly to limit access to those who are trustworthy, a program for protective security to limit access to information to those who are in fact authorized to have it, a counter-espionage program, and finally an enforcement system to punish and hopefully deter those who are violators of the system. And I think that although we've made some progress in many of these areas in the Reagan administration, in the last area we simply have not made enough progress. And it's not really a matter of developing new legal weapons, but an ability to use the ones we have. Floyd was very good at fighting the last war. That is the issue about pre-publication restraints through injunctions, like in the Pentagon Papers case. For some of the reasons that he suggested, I don't think that's what we need to solve our problem. I'm willing to accept the challenge that was laid down by Justices Stewart and Marshall in that case, that national security begins at home. It's a responsibility of the executive branch to enforce it by having a sound security program and enforcing it through its own means of punishing, firing people who violate their trust. And yet that's where the fight is going on right now. Our efforts to, for example, get employees to sign secrecy agreements, SF 189, are now under attack in lawsuits, in the media, and in Congress. People who think it's unfair to make government employees sign an agreement, a secrecy agreement, as a condition of getting access to classified information. People in Congress, including, unfortunately, some conservative senators, think that whistleblowers ought to be protected if they disclose classified information, because that's their right. There are proposals now to increase judicial review of our security clearance determinations. There's a proposal in Congress recently to let the MSPB, which has no security responsibilities, review a decision by the executive whether or not to grant access to classified information. I'm willing to accept, I think, the challenge of the courts and the scholars to try to protect national security information consistently with the First Amendment by focusing on the executive's responsibility to get its own house in order. But we can't do that if our critics continue to snipe at us when we make those efforts. And so my challenge is, and my conclusion is, that if we are to succeed in that effort or have some hope of success, we're going to have to pull together and focus on a sound implementation of a security program. If our critics inhibit that, if they keep us from enforcing security requirements within the executive branch, then I think the only other alternative is the kind of thing Professor Holzer advocated, some kind of Official Secrets Act. I don't think it's a good idea, and I think that many of our critics may be sorry if they succeed in undermining our efforts to develop a sound security regime, because what may come after could be quite much to the worse. Thank you very much.
I'm going to depart, at least initially, from the form of the discussion up to this point. Unlike the other 3 panelists, I'm not a lawyer, as most of you are. But I want to tell you how a member of the press feels about these issues, and a person who has to deal with them on a day-to-day basis in mundane or occasionally dramatic fashion. First of all, a disclaimer. No one can speak for the American press. It is diverse in character and opinion. I speak for myself, not for the press, not for the Washington Post. We as journalists believe very much in the First Amendment, which is the foundation of what we do. It is of primary importance to us that the press is the only business in the United States, and it is a business, which is protected by the United States Constitution. There is a reason for this. one of great significance. In our democratic system, there would be no way for a free people effectively to exercise their citizenship rights if they were not well and independently informed, if they did not have the potential for being well and independently informed. Our function as members of the press is to inform. The press lives by disclosures. Our job is to tell as much as we can, as well as we can, as often as we can. This is not, as you may think, a special pleading for a special cause. If you think about it a minute, the governmental and the political processes at state, local, and national levels rely on this constant stream of public and published information to a tremendous extent. It is the foundation for political interchange, accountability, and public opinion. In this, the independence and the diversity of the press are of vital importance. If you need a reminder, just visit an authoritarian or totalitarian country and look at the press, and you will see the difference. Despite the tenor of what I've just said and some of what I'll say next, the general public and many of us in the business believe our greatest fault is not finding out and publishing enough. There is much less concern that we may publish too much, because it is manifestly true that there is so much that we do not know and do not report. To government, we in the press may seem like many, but from our ranks, we are a very thin line trying to cover a vast amount of territory. Regarding national security matters, what we learn is often partial and after the fact. We are faced not only with secrecy, but often with evasions, half-truths, lies, and recently, attempts at deliberate disinformation, which is very corrosive. The Iran-Contra affair, which Mr. Willard has spoken of, to me is an example of our shortcomings. We knew nothing of it for more than a year, despite major discussions and decisions within the government, large-scale movements of money, weapons, emissaries around the world. And it is also an example, and I agree with him on this, of the dangers inherent in obsessive secrecy, unaccountable government operations beyond the tolerance of Congress or the American public. Having said this, I must also say that most of us in the press also recognize that in compelling and unusual circumstances, there are limits to what we can or should publish. We are not totally independent actors or institutions. We are also citizens. Generally speaking, we do not publish the names of rape victims. Generally speaking, we do not interfere with the tactical phase of law enforcement or military operations. In Vietnam, where I was a correspondent, I and all other reporters accepted ground rules not to disclose impending military operations. How then do we deal with the disclosure of government secrets or pseudo-secrets? I mention the latter because in my experience, nearly every recommendation, policy decision, or action in the foreign policy or national security field is classified as a secret by someone at some time, often without valid reason, except for bureaucratic convenience. A former managing editor of the Washington Post, Howard Simons, said, "It is not just improbable, it is impossible for a person to report on the foreign policy beat in Washington without bumping into a secret every day." The abuse of secrets is far more serious on the government side than in the press, I believe. A lot has been said about leaks. I won't go into that at this point. I could discuss it later. But a lot of this is total nonsense. We have to decide what is a leak. and it's difficult to define. Much information comes out of the government every day, which has no one's name attached to it, which is not a leak. A Harvard committee studied this, a study of the press and government managers. It found that it defined leaks as something, telling a reporter something you wouldn't want your boss to know you told them. That was finally the best definition they could come up with. And it found that 40% of all a group of former senior government officials said that one time or another they had done this for their own reasons, and which they found valid. Some disclosures of a major nature present legitimate and substantive questions for the press in this field because of the potential consequences of publication. Generally speaking, we know which ones these are. I'm not talking about the Aviation Week type of technical material, which it seems to me if the government wanted to stop, they could do it. I'm talking about major policy issues. Generally speaking, there's also a dialogue between the government and press before publication. This is an ad hoc, informal system which has developed over time, especially since this has become an issue between government and press during this decade and over the last 10 years. Some of the most notable examples from my own experience in the Washington Post were Bob Woodward's 1977 disclosure that King Hussein of Jordan had long been on the CIA payroll, Mike Gettler's 1980 disclosure of U.S. aid to the Afghan rebels, my 1982 disclosure, followed by a more extensive one from Bob Woodward and Pat Tyler, that President Reagan had authorized U.S. aid to an anti-Sandinista force in Nicaragua, which later became known as the Contras. Woodward's 1985 discovery, published in the Post 8 months later, of U.S. eavesdropping operations off the Soviet coast, which had been revealed to the Soviets prior to that time for pay by a former NSA employee, Ronald Pelton. In each of these cases, the government was put on notice by the newspaper and had an opportunity to make its views known if it objected to publication. In most of the cases, a high-level dialogue ensued, sometimes involving such figures as the President, the Secretary of State, the National Security Advisor, the Director of CIA or NSA, and the publishers and or editors of the newspaper. In this dialogue, the government figures had an opportunity to state their objections or misgivings, to spell out the reasons against publication if they were, in whole or in part, or for a certain period of time. The press, in this case the Washington Post, had an opportunity to point out surrounding facts and circumstances and state its views. In the end, the decisions were for the press to make, whether to publish, when to publish, how much to publish. This is an essential point. If it were not our decision to make in the end, there would be no such process, simply a flat and nearly automatic no, as under the British Official Secrets Act, or the workings of authoritarian or totalitarian governments in many places in the world. It would be a resounding and ever-encroaching no, which would be likely to do far more damage to the United States political and governmental system over time than any disclosure of the moment. In the same vein, it seems to me, nearly all the proposed remedies for governmental leaks, such as the application of espionage or theft laws to press leaks through the Morrison case or some law, as has been mentioned by Professor Holzer, would dangerously interfere with the functioning of the press in our system. The government has the right and the duty to protect its secrets against unauthorized disclosure. That is its job. I find Mr. Willard's program of painstaking and hard work to the essentials of security something that is legitimate and right for the government to do. And his 5 points sound to me at first hearing like they're the kind of thing that is called for by the government to protect its own secrets. But it should do so without threatening or damaging our right and duty to inform the public. Blunderbuss measures which have not been approved by Congress or justified to the American people are not the way to go. Let me sum up. The functioning of the press is essential to our democratic system. In the main, our shortcomings are our inability to know enough and publish enough. Our job is to publish. Second, in extremely compelling and unusual circumstances, there may be overriding reasons to withhold publication. Freedom of the press is a balancing act, not an absolute right, though the weight should be heavily on the side of publication. Third, an informal ad hoc system has evolved for discussion prior to publication of stories which are seen as particularly troublesome for the government on national security grounds. The system works, and I might add, there's been no showing where it has been used of grave damage to the U.S. national security. And finally, the final decisions are and must be in the hands of the press. If we are wrong, there will be severe public and political consequences. Publishers and editors and reporters are well aware of that. We live here too.
We hear a great deal frequently, particularly from liberals, about how activity A or law B or decision C, etc., may, quote, chill, quote, free expression. But we never hear, or at least I never hear, I think a very related point that Mr. Willard made in his presentation. And that is the fear of leaks, speaking broadly, the fear that important, sensitive, classified, highly important national security and national defense information may get out, casts a terrible chill on planning activities that are important to the American national interest. Related to this point is a point that the last speaker made. He said that the press is the only business protected by the Constitution. I would suggest that the, quote, business, quote, of survival is very much protected by the Constitution in provisions which, among others, provide Congress with the authority to provide for the national defense. And for one, not to introduce a note of acrimony into this, I am getting very, very tired in hearing that the First Amendment is virtually the only provision in the American Constitution. There are provisions in the body of that Constitution that are equally, if not more important, than the ability to express, quote, end quote, information to the effect that the American military is planning to liberate Grenada.
I'd just like to make one or two comments about what Mr. Willard said. First, for the first time here, if you're interested, but I give credit to this administration for some of the things it has not done. It is meaningful. It says something about the strength of our tradition and the force of our laws that exist and the commitment of people in the administration to the First Amendment, that there have been no efforts at prior restraint by this administration, that there have been no criminal prosecutions of journalists by this administration. For those of us, myself included, who have been critical of the administration, and we have been, we haven't talked much about that, but it is worth saying that these things have not occurred, and it is important that they have not occurred. Mr. Willard is right, I think, on a few scores. One, the battle is now being fought, I would say, a number of steps away from hardcore First Amendment terrain. It's being fought about the rights of leakers, Now, there's no constitutional right to leak. On the other hand, there is a First Amendment interest, in my view, in having certain information available. Whistleblowers, what should their rights be? I think there's a powerful case as a societal matter, not a First Amendment matter, that it's important for us to encourage people to disclose wrongdoing in government. But I'm not here to argue that now. I just want to say that those are the areas on which I would rather have my arguments with Mr. Willard. I would rather argue that this administration is obsessive, as I believe it to be, about secrecy. That's not a First Amendment violation, but it is something which is, I think, troubling as a matter of public policy and violative of certain First Amendment values. But it's a pure First Amendment matter. It's worth saying again that the reason that we have so little litigation in these hardcore areas is that we always have shared, and in part I want to say because of people like Mr. Willard continue to share some common sense and common view that direct restraints and punishment of the press, of speakers and the like, is at least as a very general and very real-life proposition unacceptable. My second observation is this. It's worth talking about one or two examples to get an idea, Mr. Oberdorfer did, and I want to offer two more, of the sort of, quote, secrets, unquote, that are published, that people may object to having published, but I think it at least helps focus our thought. Mr. Woodward's book, for example, disclosed, I think for the first time, a good bit of details about the bombing of an airport in Nicaragua, at which 2 American senators happened to be at that time. And that bombing was done, so Mr. Woodward says, and I believe it to be true, in a fashion which was supported by the Central Intelligence Agency. There are serious questions there of law-breaking by the CIA. There are, even if that were not true, serious questions of public policy about whether that sort of thing should have gone on, the degree to which this government should have been involved in that. So far as I'm concerned, it is only a good thing that that sort of disclosure was made. Second example, assassination attempt by the United States in Beirut. Mr. Woodward says there was an attempt made on behalf of the United States. Its target evaded or was not killed, but some 70 or 80 other people were killed. I make the same 2 points. First, assassination is illegal, and if we tried to do it on behalf of this government, it's against the law. That matters. That should matter to us. But second, more broadly, there are major, serious issues of public policy involved there. This isn't a question now of what should the press do in advance of a rescue effort, or what should the press do in advance of an invasion, or even what should the press do in advance of an assassination attempt, if that's what occurred. This is reporting. And I believe this is important, serious, valuable reporting. It is information which is, quote, classified, unquote. But the classification system doesn't bind you or me or the press. It can't. And it never has bound anyone but internal governmental officials. So the government, it seems to me, as Mr. Oberdorfer said, has a perfect right. In these 2 examples, I think it violates its duty to us as citizens to tell us these things, but it's within its legal rights in not disclosing things like this. And the press is not only within its legal rights, but in my view, serves us by disclosing them.
Well, I think I've discovered the hidden agenda of the Federalist Society, which is to take conservatives like me and put them on a panel where I sound like a moderate. And I hope I don't have to come up for confirmation, because maybe some Republican senators will threaten to filibuster if I come up. It doesn't make me very comfortable to have Floyd praise me in this kind of an audience, and I have to assume that if we were appearing before an ACLU audience, the tenor of his remarks might be a bit different. I would like to just make a couple of comments, though, on where we now have, I think, where the debate really is in Washington today. And that is not over government efforts to put newspaper reporters in jail or to engage in direct censorship of the press, but rather government efforts to get its own house in order and to have a good security system that will work and to find out people who are violating the security rules and punish them appropriately. That is, government employees who are violating the rules, and to punish them appropriately. And but that's where the battle is being fought. And it's a little disingenuous for some people to say, well, that's what you ought to do. You shouldn't go after the press. You ought to try to get your own house in order. And then when you start doing it, to turn around and say, well, anything you want to do to get your own house in order also is not a good idea. Not that Floyd has done that, at least yet. But that's where we are now. People have suggested that we can't use adequate security measures, that we can't use polygraphs to find out whether people are security risks or not, that we can't make security clearance decisions without being able to justify them with judicial review, that we can't require secrecy agreements of government employees as a condition of giving them access to classified information, and that we can't punish government employees who violate their obligations in this regard. So that's where the debate's being fought now, and I think that's the issue we have to confront. And what I was suggesting before, and just to reiterate it, it never hurts to make a point twice, is that if we fail in this effort, then we're going to have to look at the more draconian kinds of solutions that Professor Holzer was suggesting. I hope we don't. I think they have constitutional problems. I think they have practical problems. But that's why our attention on developing an adequate security program within the government is vitally important. And I think as policymakers, policy implementers in the administration, it is an issue that has to be confronted. I wish we had confronted it forcefully in 1984 and when efforts were underway to implement NSDD 84. Presidential directive that was aimed not at the media, but entirely at internal government security practices. But the political heat got too hot, and the administration backed off and effectively abandoned any effort to develop an administration program to combat leaks. And the result was that was one of the factors that I think led to the kind of fiasco we had in the Iran-Contra affair. I don't think that when people who are involved in these councils of government are unhappy, that they ought to have a right to go running to the press. And yet, unless you have a tight system, then it's going to discourage a use of an orderly decision-making process. I'd like to just close by reading a couple of sentences from Colonel Beckwith's book, because although this is the Carter administration 10 years ago, it could just as easily be said today about Washington, D.C. He said, "Early on in the planning of the mission, I was embarrassed to learn that Delta could not coordinate with our State Department, those contact points we'd taken a lot of time and effort to establish. Because of State's notorious reputation for not being able to keep a secret, DOD ordered Delta not to talk to State. Somehow this problem with the State Department must be overcome. In the future, every appropriate agency in our government must be used." I'd suggest the problem has not yet been overcome.
I've basically had my say, and I've nothing to say more except that I don't want my silence about Woodward to be misconstrued. Not that he needs any defense from me. He is one of the most respected journalists in Washington, does wonderful work, incredible work, which I honor and respect.
All right, questions from the floor?
Mona Charon, speechwriter for Jack Kemp. I have a question for Mr. Oberdorfer. You did sound like the soul of sweet reason, and in fact you were even quite moving when you said we live here too and we are patriotic. But when you described the high-level negotiations that take place between government officials, including, you said, the president, and publishers of newspapers, what you're saying is that matters that affect our national security and perhaps even our lives are, on the one hand, being negotiated by people who have had to be elected by the people, certainly have had to have FBI investigations of their past and of their loyalties. This is not to question that there are people in the government, as we all know, who are wacko. However, when you're dealing with the press, there are no such safeguards built in. The people who become editors of newspapers and therefore hold this very important power in their hands need to pass no such test. And I'm wondering how you would respond to the possibility, just the hypothetical situation, of a lunatic as editor of the New York Times.
I'm glad you mentioned the New York Times. No, seriously, we're not elected. We know we're not elected. We don't want to be elected. And we realize that the government has many powers and responsibilities which we do not have. What I have described is reality concerning many of the sensitive questions that people get excited about. And you may find things that are ironic or difficult or inappropriate about it, but we are rather practical about it. If there's something about this story that is so potentially damaging to the security of the United States that we should not publish it or not publish all of it or should withhold it for a certain period of time, we think it makes more sense to find it out today rather than after the article is published. And so there's a dialogue. Now, the question of how far up the line of the chain of the governmental command government wants to respond is its decision. But I don't think there's any alternative for the press if it's going to be both a free and responsible press than to carry on this kind of dialogue with the government. I don't believe there's much likelihood of a lunatic becoming editor of the New York Times or Washington Post or CBS or somebody else. We just, we have institutions and we have ways up the ladder, and I don't think that would ever happen.
I have two questions. The first question for Mr. Willard. How many employees of the Department of Justice have been fired in the 7 years that you've been there for unauthorized leaks of any information, whether it be national security or 6E materials? Secondly, how many employees or how many political appointees anywhere in the government for any reason have been asked to leave or resigned or fired for unauthorized leaks?
The numbers are not very good at all. The only case I know of a Justice Department employee offhand, and there may be others that I just don't know about because I'm not in this business, is we did fire early in this administration. William French Smith fired a U.S. attorney for an unauthorized disclosure of classified information in California. I think that contrasts favorably with the record of a number of other departments where people who have been caught leaking classified information have been either allowed to keep their jobs or steal off silently into the night with their retirement benefits intact. I think that's been a problem in this administration, an unwillingness to discipline its employees, both political appointees and career appointees, who violate the security rules. And I think that's something we need to do something about. Is I think, part of our problem.
Well, then it seems that your reliance on policing our own house is a rather hollow remedy, it seems to me. One U.S. attorney, which I'm familiar with being fired for unauthorized leaks, when there has to have been a lot more in this government or in any government. You got one person that you can point to? I mean, that's a program?
I understand the problem. Now, with regard to leaks, of course, most leakers don't advertise who it is that's doing the leaking. I think the definition we heard earlier is probably a pretty good definition of a leaker. It's someone who provides information they don't want their boss to know they're providing. So a part of your problem is finding out who they are. Your logical way to solve a leak case would be to take the person you know who knows something about it and ask them questions. And that's the reporter. But the reporter won't tell you. And if you take him in front of the grand jury, he still won't tell you. He'll become a martyr. It's very difficult to use your traditional criminal investigative tools to find out who's doing leaking. But you can solve some of the cases, and we have. And I think part of our problem is an unwillingness to impose the kind of sanctions we should in the cases where we do catch the leakers, and we ought to do a better job of it. On the other hand, when we do catch them, they shouldn't be protected by the whistleblower law or the MSPB or anyone else from their just deserts.
brief question for Mr. Abrams. Are there any categories of information at all which you would consider to be appropriate for a prior restraint and or a post-publication criminal penalties? Anyone at all, and if so, what would be the standard you would apply? And specifically, the same question with respect to the following types of categories of information. Weapon systems, technical aspects of weapon systems, troop movements, pending invasions, commercial trade secrets, and codes. And third aspect of the question is, what is their position on whether or not criminal penalties could apply to the press knowingly receiving stolen property and publishing it and or causing it to be stolen? I'm sure that there's
Why
a
did
number.
you ask me the questions you asked Mr. Willard? I knew that answer.
Feel free to answer that one too.
Well, let me just answer it in general. I do think that if it were all up to me and I were able to reorder all of this, I would try to make a very short list of materials which could be punished for publishing. It would be short. We already have one on the list by statute, well, maybe more than one. Certain atomic energy matters, certain code matters are on the list already. Already, both of those have raised some serious policy issues. As our society becomes, a few years ago, I would have just loosely said certain technological details of weapons systems, and phrased as loosely as that, I can live with it. But we should take note of the fact that as technology changes, as arms controls agreements, for example, become more and more dependent on verification, it becomes more and more important to be able to talk about these things. And you can't talk about them without talking about them technically. One of the problems I had with NSD 84, and I want Mr. Willard to go away happy today, not praised all the time. One of the problems I had with NSD 84 was my view that lifetime pre-censorship agreements with government employees would deprive us of the chance to have people who leave the government and who know about these technological things, which I can barely use the words about, comment on and deal with in a way that is meaningful to us, agreements, treaties, and the like. The idea that NSD 84 was lifetime in scope was not only a little too long for me, but would have assured that we would not have had the benefit of the views with the people best able to give it to us. So as a general proposition to respond to you, yeah, I think that there are a small category, and I can't tick them off now, of materials which I think it could constitutionally be made appropriate to punish for publication of. Well, what can we have prior restraints on? Even less. But at least I'm content to live in a regime in which we have the prior restraint law we have now. Now, I should tell you the prior restraint law we have now is something of a fraud, because we say we can have prior restraints, but we really can't. That's one of the reasons I'm comfortable with it. The fact is we have made it very difficult, very, very difficult. I mean, if Justice Stewart's opinion in the Pentagon Papers case, which is the last national security press case we've had, is the law, or the best statement of the law, what is required, at least absent a statute, is direct proof that publication will surely result in direct and immediate and irreparable harm to the country. Now, when you put surely in, and he put it in on purpose, and for reasons that I think are suffused with First Amendment meaning, when you put surely in there, what you're saying is that there is hardly a case that the government's going to be able to prove its need for a prior restraint. I think that should be the law. I don't think we can rely, even if I liked prior restraints more or feared them less, I don't think we can rely on prior restraints as a method of protecting secrets. They're idiosyncratic. You can only get them when you know about the fact the press is going to publish something. You only learn that if you're in the government, and often, at least, when the press calls for comment. They won't call for comment if we lived under a regime of prior restraint. It is not a good way to keep secrets, and it's not a smart way to keep secrets, and it's a very troubling way to keep secrets. So I think there is a little list that I could sign on to, but it's not very long.
Next, please. Yes, I'm Jeanette Burridge from Seattle, Washington, and I have a question for Mr. Oberdorfer. It seemed that I got the impression that you were in agreement that the government should be able to keep secrets when it could, and I was wondering if a surprise military operation such as that in Grenada is one of those areas where you think it's inappropriate for the government to keep a secret if it can.
Yes, your impression was correct. I do think that it is a right and responsibility of the government to keep legitimate secrets. That's their job. My job is something else. With regard to military operations, I mentioned what I accepted in Vietnam, and I agree with that. I don't think the American press should, I don't believe, it should publish or broadcast something in a tactical situation as American troops are going into battle. I think that would be the height of craziness to do that. And that's the way I feel about it.
Yeah, this is for Richard Willard. I think the colloquy with the previous questioner at this microphone may have been more damaging to your comfortable moderate and centrist position than is recognized. As Mr. Abrams and that colloquy pointed out, this administration has not stopped leaks. No previous administration has stopped leaks, and no future administration is likely to stop leaks for the simple reason that it's extremely difficult to identify who it is that's doing the leaking. By contrast, it is relatively easier to identify persons who are about to publish or disseminate information already leaked. As a practical matter, it may therefore be that the only effective way to reduce leaks to any significant degree is to reduce the incentive to leaking by making it extremely costly for the likely recipients to disseminate, publish, or do anything with the information. So when push comes to shove, aren't you really going to have to choose between Holzer, Abrams, Holzer, Abrams, Holzer, Abrams?
I don't think that that's necessarily true. For one thing, as Floyd pointed out, and has been our experience, every time someone comes running to us to try to get a prior restraint, the practicalities of prior restraints are such they are a very unwieldy weapon, and they just don't work very well at all, as the government learned in the progressive case in the Carter administration. Just because you get an injunction doesn't mean you've protected the secret. I do think that there is progress that can be made in identifying leakers by the use of good investigative techniques that don't involve taking reporters and requiring them to disclose their sources. It does require, though, a commitment of resources to do the investigations and then of backbone to follow up and fire people, whether they're popular or unpopular or political appointees or not, or to impose some other kinds of heavy penalty on them for violating the rules. So I think it is possible to develop a system that works. I would say also it's easier to find the leakers if you can use the polygraph on them, as the Carter administration discovered in the Abscam leak probe. But you have to be willing to take some heat. And the problem is that the payoff of cutting back on leaks and of improving our security posture generally is in the future. But you have to incur an administrative and political cost now when you undertake the effort. So it means that an administration has to have enough foresight to recognize that they need to invest political capital in a program to prevent problems from occurring in the future, and that's always very difficult to sell in Washington when the time horizon is usually this afternoon's deadline for the evening news.
Can I add just one thought to that? Gary?
Please.
Am I live here? If you can't get prior restraints on the recipient of the leak, and I agree with everybody up here, and I think you'd probably agree with this too, that it's very hard, if well nigh impossible to get, you can still nail the one who uses it and maybe discourage him or her or others in the future from using leaked material and thus maybe help dry up some of the leaks. I don't agree with what Mr. Abrams said, where he said, in effect, if you've got it, you can use it. I mean, it sounds to me like that's a notion comparable to getting good title from a thief.
I had the fence analogy in mind.
Yeah, well, you'd be right. That once you somehow manage to get it, it in effect immunizes the guy who stole it or the leaker and your use on some theory that it's now once removed or more removed from its source. And just as you can't get good title to a thief, though I'm not a property lawyer, I think that's still the law. It doesn't seem to me that if you can get it, you can use it.
Well, could I add a comment to that? Because I think that's a good point. I believe in using criminal statutes to go against fences, whether they're fences of stolen property or fences of stolen information. But the problem the press has is they usually don't know, or in many cases don't know, because this town is a torrent of leaks, some authorized, some not, some from people who have the authority to declassify, some from those who don't. And it's not always possible for a newsman to know whether he is in fact receiving stolen goods or not. I think in the case, and there are a few cases where you could prove that a journalist is knowingly receiving stolen property, that imposing liability under criminal law may be appropriate. But I think that would be a hard case to make in most situations where, and again, I think that the responsibility really should be put in the first place on the government official who violates his oath of office and the trust of the American public in disclosing the information, rather than putting the burden on the media.
It should be said that there's at least a very major issue, at the very least, as to whether the government, if one must talk in property terms, as if we're talking about who owns a jar of jam or something, whether the government owns the information. That isn't the right analogy, I think, anyway. I mean, I guess I start with the proposition that information that any of us have, we are, absent some extraordinary extremity, free to take account of, to use, to tell people about. People in the government are different. They have different obligations. But it seems to me not at all far-fetched to say that people who have information, you keep referring to it as property, who have information, can and should be able to make use of it.
I don't have the opinion here, but it is my recollection that the formulation in the Pentagon Papers opinion, to which I think Mr. Abrams referred as the condition for imposing a prior restraint, is direct, immediate, and irreparable harm.
That's correct.
And I ask anyone who cares to dispute me if immediate is not an unfortunate and excessive and undesirable limitation. Surely the government has not only weapons technology, but military doctrine developed over many years, conforming to the characteristics of billions of dollars worth of equipment, whose disclosure may not result in immediate harm to the United States, but surely should be restrainable by prior restraint. And I think that if it's not, it's rule of law unwise, just as I think Brandenburg against Ohio is unwise in saying that advocacy of the violent overthrow of the United States government cannot be restrained unless it is directed to producing imminent lawless action and is likely to produce it.
Well, you know, in the Pentagon Papers case, this needs to be said because that case has been bandied about so much here today. If you can find a clear-cut majority or even plurality opinion in that case, I'll buy you dinner at the restaurant of your choice. There's a short per curiam opinion.
The press is happy to copy out this phrase every time
It's a
there's
short
chance.
per curiam opinion of maybe 4 paragraphs. I have it before me. And then the 6 went off on frolics and detours of their own. And I'm not sure what the law is there.
Well, the usual way that most of us that practice this for a living to make determinations as to what the law is to pick the concurring opinion which affords the least protection to the press, and to say that at least the press had in 1971 that protection. That is the Stewart White opinion to which the last questioner accurately made reference and quoted. I would say that there is no more important word, and I'm sorry I left it out, no more important word in that formulation than the word immediate. And no more important word in Brandenburg, with which I also agree, than the word imminent. These are, I focused on surely, but surely what? Surely immediate is what makes it so very difficult to prove. I disagree with the thrust of the questioner, although I think his question is acute. If you've got to prove that publication of something will result, let alone surely result, in some immediate harm of enormous damage, it's very, very unlikely that you're going to be able to do it. The question is, if we're talking about policy now, should the test be that hard? I think it should be. I think anything less than that results and will inevitably result in a series of speculative assumptions by government officials who are deferred to by judges and will be deferred to by judges on grounds of expertise of those officials, to the effect that if this is published, then that may happen, and that may happen, and that may happen, and at the end of the line, we will what? Your example has spent a lot of money. I would think that would always fail as a reason for a prior restraint.
Well, also millions of man-hours of work.
Money. That's
human effort.
Well,
But you
The
see,
resources of the United States.
you miss something about that case. Shot through that case is the notion that the government was not able to stand on a statute in seeking that injunction. And that's the difference between, in my view, the Pentagon Papers case in some measure and the progressive case at the district court level, because there was a statute, there was the Atomic Energy Act, and it was very clear that that district judge could stand on it. Therefore, if you could get yourself a statute giving more latitude to these things, you might have a different result in another Pentagon Papers type case, assuming the injury and the damage was there, which it ought to be before you can get one of those things.
All right, we'll have 3 more questions.
Okay, my question's directed to Mr. Willard. It goes to defining the scope of the problem as well as the prudence of the current law. And I'd like to ignore the prior restraint and other contexts. Mr. Abrams says there was no harm done with the publication of the Pentagon Papers and other such leaks. Mr. Holzer suggests several, and you've pointed to sort of process harms in making decisions. Another possible harm that's often proffered is that governments that we need to cooperate with or do cooperate with who might be embarrassed should it be known that they cooperate with us on diplomatic, foreign relations, or military matters, might in the future refuse to do so. I want to know, is this a serious concern? Do you have any reason to believe that this is another potential problem with these type of leaks and that this is a potential concern that should be addressed in the law?
Well, I certainly think it is a concern and a legitimate one. I didn't want to suggest that the problem I pointed out was the only reason we have a problem. I think there are lots of problems posed by leaks. One is the monetary problem that the last questioner brought up, the fact that a leak can compromise a very expensive intelligence system, which we've spent millions or billions of dollars to develop, and it becomes worthless as a result of a leak. The one you've suggested about cooperation is certainly real in my experience. It's always hard to quantify that kind of a problem, because you don't know what you're not getting as a result of your poor security posture. At least in most cases, you don't know for sure what you're not getting. So it's hard to be precise about it. But certainly people who work in the field of intelligence believe, and I think they have good reason to believe, that there's a limit to our cooperation. And that every time we disclose, whether through leak or otherwise, cooperation that's given on the assumption it would remain secret, then it makes people less interested in sharing a confidence with us in the future.
If I might add, I think there is a problem for the government, but it's easily overblown. Henry Kissinger said that the Pentagon Papers leak was so devastating to U.S. contacts overseas that we could not have decent relations, for example, with China. Well, look, we have fine relations with China. We've had all kinds of cooperation with China, and it's easy to theorize about the terrible things that are going to happen in some particular case, and it usually turns out to be wrong.
Larry Uzell with the Scripps Howard News Service. This one is for Mr. Abrams. You said that you've never met anyone who thinks that there was irreparable harm from the Pentagon Papers. You can't say that any longer because you've now met me, and I think there was irreparable harm. And I think that there are a lot
I'll never say it again.
There are lots of people who live in what used to be called Saigon and is now called Ho Chi Minh City who would agree with me. Hypothetical question. Let's suppose that the state of First Amendment case law and the state of journalistic practice of editors and reporters deferring to the judgments of government officials on national security in that dialogue that Mr. Oberdorfer talked about were the same today and had remained the same as they were in the late 1950s and early 1960s. And let's suppose that as a result of that, in Indochina and Afghanistan and Angola and Mozambique and Ethiopia and Nicaragua, we did not have Leninist regimes. Would you rather have that or the situation that we have today?
I think it's the strangest choice I've ever had. I think I will say again what I said before. I can't understand a question which asks, would I rather have a system of cooperation, sometimes collaboration between the press and the government as it existed at a time before the government started lying to the press and the public on a consistent day-by-day basis about the progress and the nature of the war in Vietnam, on the one hand, and on the other hand, the absence of Leninist governments. I would wish that the Leninist governments, the ones that you've listed, I think all of them, would not exist. And I would not wish ever for a return to the days of the 1950s or 1960s in terms of the nature of press coverage of government. The only thing I would wish for, though, or to rephrase it, I think it's very important to at least repeat, as Mr. Willard said earlier, one of the reasons why those days ended of press-government cooperation. It ended because, at least in the view of many of the people outside the government and many people in the press, they couldn't trust the government to tell the truth. Now, if that hadn't happened, I don't know what would have happened, but I don't think it would have impacted on the Leninist states in those countries.
I take it that you're saying that the government was lying on a more consistent and more outrageous basis under the Johnson administration than under, say, the Eisenhower administration.
That's correct.
If the Reagan administration and the next administration were, in your view, as truthful as you think the Eisenhower administration was, would you urge journalists to become less adversarial than we are today?
Mr. Oberdorfer, how about that? I keep my clients by not urging them to do things journalistically, but if it were up to me, if they really wanted to know my sort of political views on that, I would think that if government could be trusted more, there would be less need for the press to be as adversarial as it sometimes is. My own view, for what it's worth, is that the press is not adversarial enough. That we would be better served by a press more adversarial than we have now.
All right. I see there are two more questioners. Before they ask their questions, let me make some announcements. I see that there has been a schedule change for tomorrow. Judge William Webster, director of the CIA, will be speaking at lunch. The schedule will be that at 11:30, Professor John Norton Moore will speak here in this room. At noon, lunch, that's a new time, in Constitution Hall upstairs. At 1 o'clock, Judge Webster speaks. And after this meeting, I believe, we adjourn to the grand hallway outside the Constitution Hall for the reception and banquet. Okay.
Yes, this is directed to Mr. Willard. You mentioned the loyalty oath that the administration wanted government employees to sign not to leak classified materials. On its face, that would seem fine, but there have been times in the past when the classified stamp and the top secret stamp have been so abused, and in fact, in the future can be abused to cover up either one administration's embarrassment or an individual's corruption. Do you recognize those possible dangers of this loyalty oath that would prevent the revealing of this information that is vital not just to keep the Washington Post happy, but to keep our government running as efficiently as possible?
I think those are legitimate concerns we hear a lot about. President Reagan's executive order on classification forbids the use of classification to cover up wrongdoing or embarrassment. And we have available now mechanisms for getting at that problem, including the availability of judicial review under the Freedom of Information Act to decide whether or not information has or has not been properly classified, as well as other mechanisms, inspectors general and others, safeguards. So that I don't think that people who confront that phenomenon in government have to resort to self-help through leaks in order to obtain redress. So it seems to me it's not necessary for that to happen, and that furthermore, the decision about what is or is not proper is not one which always should be subject to the lowest common denominator of whoever feels like disclosing it being able to do so. Frequently there are disagreements about whether something is properly classified or not. In my view, those should be addressed through an orderly process, and in our current system we have the safeguard of judicial review, rather than on an ad hoc basis, whoever thinks it's not properly classified just passing it out because they feel like it.
Doesn't the review process run sometimes through the very people that may be covering up either an embarrassment or corruption? In fact, even in the Inspector General's office, is not just at the federal government, but at the state level, there has been corruptions there. Now applying it just to the federal level, there is that danger as government grows more, and government regrettably will continue to grow more. It by its very nature becomes more intrusive and oppressive, and it is harder to get the truth out of the government, and at the lower levels sometimes is the best sources. By lower levels, the government worker who has integrity and is concerned about the quality of the government that the people are getting.
Well, I guess it depends on what your perspective is. We've heard different ones here. My own perspective is that our government keeps far too few secrets rather than far too many. My experience in this town has been almost nothing stays a secret, or it doesn't stay a secret for long. And that if you tell more than one other person, and sometimes if you just tell one other person, you might as well go ahead and publish it. I think those few instances where we are able to keep something secret are fairly rare, and far too rare, rather than the opposite problem.
Well, sir, maybe we can agree that maybe the wrong things are kept secret in this town. Thank you.
Mark Seidenberg, I'm with State Department Watch Limited. My question is to Mr. Willard also. I've got a question in the expansion of Executive Order 12356, Section 1.6, which you just mentioned, on dealing with embarrassments. Can you expand on whether, in your view, embarrassments to foreign governments are included within that portion of that executive order?
I don't know. I guess I think that the touchstone for classification is the American national interest, the interest of national security. And it's a little hard for me to address that in the abstract. I think you'd have to look at a specific case and see how it would be applied. That particular issue really hasn't been raised to me before, so I can't give a more definitive response.
I'll give you an example. When Miroslav Medved jumped ship in New Orleans, I happened to get privy through telephone information that who Mr. Medved was and what the situation was. That was on the like a day after he jumped ship. At that time, the State Department was saying that Mr. Medved was, one, a Russian, and two, was not disclosing his name. When I found out what happened, I went and into the process and hired an attorney in Belle Chase, Louisiana, to try getting a next friend for Mr. Medved, knowing the situation that occurred. At the time, I was getting phone calls from the State Department telling me this information is all classified, and I informed them couldn't be classified. I got this over non-voice secure telephones. And but anyway, that was an example. But they were claiming it's going to be embarrassing negotiations with foreign governments, i.e. Russia. And I was wondering, in that kind of a scenario, would an embarrassment of a foreign government, let's say, i.e. Soviet Union, be fall within that category of that portion of Executive Order 12356?
I just don't know enough about the facts of that case really to have an opinion on it at this point.
Okay, well, thank you.
Thank all of you.